30% each, the chair getting 40% of the total for doing all the work. One should prefer a system in which you have one arbitrator, possibly paid more. Both clients the parties would save costs, and even if you pay the sole person, the sole arbitrator a little more, you still save costs and probably time, because again, to find a time frame or dates for hearings or anything, when you have three arbitrators, one being appointed by the defendant, who by definition has no incentive to go fast, is not going to help in terms of time. So in those cases, when you sell a turbine, for instance, I would say one arbitrator and ICC standard arbitration clause, for instance, or any other standard clause, and that's it. And if you cannot even choose the venue, the ICC will pick it for you, and they will always choose a neutral venue, so that will work. So I think a standard ICC clause, for instance, with a sole arbitrator when you sell turbines is a good thing. Now, for LNG contracts, we have done a lot of that. It's very interesting, long-term LNG contracts, for instance. You know that the amount in dispute is going to be very large. In that case, you may want to say three arbitrators. So you may even say three arbitrators if the amount in dispute is more than 20 million or whatever. Yeah. But if you assume that it's going to be difficult in any event, or it will be a matter of principle, maybe in LNG contracts you would say three arbitrators, but then pick a venue which is very pro-arbitration, which with no court interference whatsoever, and you will save money. Of course, not India, but you know, Geneva, Zurich,
or Paris. Yeah,
Paris. You know.
Even Milan is actually for these sorts of things.
Milan is fine.
Rome,
Milan is fine. So. The only problem in Italy is that they still have a law which says that provisional measures cannot be decided by arbitrators. It's exclusively for the courts to decide on provisional measures. So that's one little twist with Italian law and arbitration, but it's a nuance. It's a detail. I think Milan would be fine.
So for the non-arbitration lawyer, I mean, what you're saying is that if we wanted to get the equivalent of an injunction, we could do that with the arbitrators if it was in Paris or Geneva or Zurich, a very pro-arbitration location. They had a very pro-arbitration law. But if it was in Milan, actually we had a case in Milan where we tried, you know, it's even questionable whether arbitrators can or can't, and we had
the answer is probably they cannot.
We had an arbitration, the answer is probably they cannot, and we had an instance when the arbitrators refused to issue provisional measures because they felt that they probably would have been unenforceable anyway.
Right, and when you go to the courts, then you have to translate everything into Italian and so on. It's not really practical because your contracts will be in English. I mean, the option to go to the courts is not a good one. Also, maybe you want to discuss the issue of pre-arbitral referee, because that's an option. You can insert in the contracts a clause which provides for ICC pre-arbitration referee. And if you are in need of a provisional measure, you can have the ICC appoint someone. They take 7 days to do that. And in a month, you have a decision on provisional measures. And it has been used in a number of cases. We represented parties in 4 or 5 cases, mostly as claimant, but also as defendant in one case. And we can say that it has been extremely helpful, especially when you are dealing with a government, because when you're dealing with a government and you need provisional measures, the last thing you want is to go to the courts of the country of that state to obtain provisional measures. Of course, Egyptian courts are not going to say that the Egyptian government is wrong and should pay this or that, or should do this or that as an injunction, even less than on the merits. So this system is extremely helpful.
Yeah, we should. I think what's emerged from our discussion is that we may want to take a look at the ICC clauses or the dispute resolution clauses that we have that recommend ICC arbitration. One would be to include the pre-arbitral referee process, which sounds like it just, there's nothing but upside there for us if we include that. And as a seller, when we're selling equipment and services. The other is that the ICC also has ADR procedures, mediation procedures that they offer, and they've got a combined clause. We probably want to include that as well. If we were to go in and retouch our standard ICC clause, maybe we want to say include the pre-arbitral referee process, mediation before arbitration, and then arbitration with just a sole arbitrator for disputes under, say, under $20 million.
That would be my preference. That would be my preference. I think if you do that, and if you choose a good venue for arbitration, a very pro-arbitration venue where you have so little court intervention that even foreign lawyers, you don't need local lawyers. That doesn't exist in France. I mean, you need, you can litigate yourself, or the court intervention being nil. The arbitral process is viewed as autonomous, and the only thing you can get from the courts is a review of the award at the end of the day. If there is a violation of due process, for instance, one party has never seen a document which was used by the other party vis-à-vis the tribunal, for instance, in gross cases like this, it would be a violation of due process or violation of international public policy. For instance, the case is based on racial discrimination or something gross like this, but it's a very lean standard of review. Therefore, your award will be final, and that also speeds up the process.
You know, I'd like, well, just for the benefit of some of our lawyers in the organization and some of the commercial folks they work with, of course, point out that, you know, if we could always dictate what we'd like to see in the contracts, well, maybe we wouldn't have jobs if life were that easy and we could always just get what we wanted. You know, unfortunately, we're not always going to be able to get the Parises and the Genevas, and maybe not even the Londons or New Yorks or Milans, but we get asked, you know, as we grow as a company and accept risk in different countries, you know, we get asked to, you know, to do dispute resolution in places where we really would not want to wind up in the courts for any reason.
Often, there is a trade-off. Often you can say, I accept the law, your law, because you're the national law of the other party, and as a trade-off for that, I want to have an arbitration, not in my country, maybe in my country, but it's easier to have them accept an arbitration in a neutral place. So yes, you have Nigerian law, but at the same time, you secure an arbitration in a different country.